Yes, Mr. Simons. I was looking over the adjournment at the provisions of Section 173A of the 1990 Act, the Planning Act, which has the express power to withdraw planning enforcement.
Yes, that's right. That's exactly what I was about to inform your lordship of. Right. You've no longer need to do that. Right. But yes, that's the provision, my lord. 173 capital A, subsection 1.
Yeah.
I was sort of moving towards the end of what I had to say about withdrawal. The question was asked before lunch by my lord about what happens if the Forestry Commission issues a Section 24 notice, which it turns out, for whatever reason, was manifestly in error. And I gave an answer about, well, there's the appeal procedure that could lead to it being, in the end, cancelled if that's so under Section 25. In that connection, it is worth reiterating the discretion that arises for the Forestry Commission at several stages of this exercise. By this exercise, I mean the key steps, if you like, in the regulatory regime. The many exercises of discretion are required. Firstly, on whether to grant a licence at the beginning of the process. Secondly, if a licence is to be granted, what conditions should be imposed? Thirdly, assuming that conditions are imposed and that they are thought to have been breached, whether or not to take enforcement action for failure to comply with those conditions. And fourthly, my lords, even if we get that far in the game, so there's thought to have been a breach, there's a decision taken to issue an enforcement notice under Section 24, that still gives rise to the final question of whether to prosecute, because it's not a done deal. There's the element of discretion, at least for that 2-year period after the offence is thought to have arisen, whether or not to issue proceedings in the criminal courts. So there's several areas of discretion for the Forestry Commission to reach views on, but the scheme of the legislation is clear. If the Forestry Commission, decides to refuse a licence or to grant a licence but to make it subject to conditions that are not thought appropriate for whatever reason, the recourse is to seek a review of that decision under Section 16. If the Forestry Commission, decides to take enforcement action under Section 24 for whatever reason, the recourse is an appeal under Section 25, and that can lead, depending on what happens, to the notice being cancelled. It may not, but it may.
Are there any provisions at all, you'd have to remind us, or me anyway, for variation or waiver of provisions
in a Section 24 notice?
Yes. I was thinking about that question because when I was reading the notes in the encyclopedia for the Section 173A provision that we mentioned just now,
yes, my lord.
There was mention there of those concepts.
Yes, there is in that context. That's quite right. There are express provisions for that, but no, nothing similar for Section 24 notices. The options are that on appeal they can be confirmed or they can be cancelled, but there's not the ability to modify or to vary.
We're thinking here of the Forestry Commission.
Yes.
Powers.
Oh, I see. Yes.
Yes, not the ministers.
I'm sorry, my lord. Yes, quite. Well, then the answer is the same, which is that there's no express provision to allow modification.
Right.
If the Forestry Commission decides to prosecute for breach of an enforcement notice, or what's thought to be a breach of an enforcement notice under Section 24, then the magistrates will in due course have to decide whether to convict, and that may require a consideration of any defence raised in terms of a reasonable excuse, which is the language of the legislation. All sorts of exercises of judgment, of evaluative judgment on the facts, are required both of the Forestry Commission and of others in the way that this regulatory regime works. Nothing unusual about that. But what we have, this is my core submission, is a statutory scheme. When you add up the effect of all of these provisions, we have a statutory scheme which functions perfectly coherently without the need for any implied power to withdraw a Section 24 notice. And again, the proof's in the pudding, if you like. We can tell that's so because we've got this far down the track and there's never been the need for the court to imply one. That's because the Act works. And that's particularly so on the facts of a case like ours, where there is no suggestion, my lords, either that the original licence or that the Section 24 notice issued pursuant to that licence was anything but lawful. Neither one of those steps subject to any challenge. And finally...
That goes back to the
it does.
facts. I mean,
it does. No, my lord, yes, quite so. It goes back
we're
to the
looking
facts.
at the principle.
The principle. Quite so.
And your answer to my Lord Justice Holroyd's question before lunch
Yes.
did involve the phrase, "we are stuck."
Yes.
Which a man say, and as a court, you hear that and you think, gosh, that's not very, well, I suppose ultimately it's not very attractive.
No,
I mean, you say, well, it wouldn't arise, and you've made your submissions about the various stages down the line.
yes.
The various exercises of discretion.
Yes.
But as an answer, "we are stuck" is not the best answer that one hears from counsel in answer to questions.
Take my lord's point. What I perhaps should have put it in this way: that what we have to do is to engage with the scheme that we've got, not the scheme that the applicant wishes that we had. And the scheme that we've got deals perfectly cogently with the circumstances, not only of our case, but of all the other cases that are arising. And as I've said already, we can tell that by the fact that so many decades into this regime, the court's not been required to imply any powers to withdraw. So we have before us a scheme that works. And it's said today, not only is there a power to withdraw, but acting rationally, the FCC, the Forestry Commission, could do nothing but withdraw. Again, taking it back to the facts of this case.
Well, those are two different things.
They are two different things, yes.
One might have a power,
Yes.
which has to be inferred in the way that Mr. Justice Richards, as he then was, said in Everett. That doesn't necessarily mean that a failure or refusal to exercise that power would amount to a justiciable act in itself.
That was going to be my submission, my lord. No, I mean, that's exactly so. So Mr. Elvin's step one is that there is such a power, which I've made my submissions on that. And then he takes it further, which is to say, on the assumption that there is such a power, acting rationally, the exercise of that power must be to withdraw on the facts of a case like this, he says.
I think there is at least one case in the planning sphere in which a planning authority was held to have acted irrationally in not taking enforcement action. I'm trying to remember the name of the case.
I'm bound to say
Don't worry. It'll be there when I go and look for it.
The core, I think, the core point that we want to make on this question of not only the power but in effect an obligation to withdraw, or not I say an obligation in as much as the Forestry Commission could not rationally do anything other than withdraw, which is the effect of Mr. Elvin's submission. The core point is that it is predicated on the earlier submission about subsuming, about the section 9(4), and the argument that based on that section that Parliament intended planning permission to be a trump card, etc. He says that from that he infers the intention that Parliament expected or anticipated or intended planning regime to subsume the forestry regime, and so for that reason the submission runs the Forestry Commission, acting rationally, could do nothing other than withdraw if they had a power to so do. That's the line of argument. Well, on our analysis of the case, because the argument on the trump card is misplaced for the reasons that I've made submissions on before lunch, the conclusion that Mr. Elvin reaches is also misplaced. There is no subsuming, there's no subordination, etc. There's no parliamentary intention based on section 9(4), the exclusion provision that we've looked at. And so for those reasons, the idea that the Forestry Commission could only do one thing rationally in these circumstances, which is to withdraw, doesn't get off the ground.
Yes.
My Lords, I was going to turn away then to some remarks on procedure on the question of delay, which won't take long. As the court's aware, Sir Ross Cranston on the papers decided the application was out of time because he analysed the challenge as being to the Section 24 enforcement notice, which was issued in July of 2020, as we've seen. And Mrs Justice Thornton agreed with that analysis, and it may assist the court. I don't ask you to turn it up now, but in her judgment, in the chronology that she sets out at paragraphs 4 to 9 of her judgment, which dates that I've taken the court to already today, but quite usefully set out there in the judgment, which I won't repeat. And again, with the very greatest of respect, both of those judges got it right for the reasons that they gave. If the court could perhaps just one last time, for the purposes of my submissions, to the Section 24 notice itself, which the court has. It's supplementary bundle page 188, and that is tab 14.
Yeah.
The submission is a simple one. Since July of 2020, the Forestry Commission has required the appellant to take the steps which are detailed in the schedule to this notice. That has been its position. Since that point, the position has not changed. It has been consistent. There's been no alteration, no deviation between then and now. To put that submission slightly differently, there's been no relevant decision taken by the Forestry Commission since the issuing of this notice, which was in July of 2020. And as I've already submitted, don't need to go over it again, but there was no appeal against the notice. There wasn't even a letter responding to it, still less challenging it, for some 6 months until January of 2021. And that letter, just for my Lord's reference, is the one which starts on supplementary bundle page 199. That comes in January of 2021. By then, of course, well outside the time limit for any challenge to the July 2020 notice.
Can we just remind ourselves of the grounds on which an appeal may be brought?
Oh,
I'm
yes,
sorry, I know you did this just now.
Not at all. So an appeal may be, if my Lord has the authorities bundle, it's the Forestry Act, section 24 and 25. So section 24(1) sets out the grounds, the two grounds upon which it's possible to issue an enforcement notice in the first place, i.e. It's A really that we're interested in here. So it's 24(1)A. Works required to be carried out in accordance with conditions of a felling licence are not so carried out. So that's the key, because B relates to felling directions, which doesn't arise on the facts of our case. But anyway, that's 1A and B, and then it's 25(1)A and 25(1)B, which have the corresponding grounds of appeal. So it's if someone claims essentially that either one of those conditions in 24(1)A and B aren't met. Now, that's the chronology. It's true that the applicant wrote to the Forestry Commission several times, starting in January of 2021, with the letter that I've just given you a reference to. Each of those letters, over the course of those first few months of 2021, generated a response from the Forestry Commission. You have all of this correspondence in your bundle. However, those responses, my lords, do not represent public law decisions, what they do is to reaffirm the reasoning that stood behind the Forestry Commission continuing to seek compliance with the Section 24 enforcement notice that it had issued many months before. And with respect to the applicant, the exercise of generating new letters from the Forestry Commission to keep a 3-month clock alive, if you like, for the purposes of a judicial review, is an artificial one. That the judicial review time limits are short ones for a very good reason, as this court very well knows. These are public decisions. These are the impacts of these decisions sometimes go much further than the parties directly involved. This court has stressed time after time for many years the importance of acting with the greatest celerity in bringing challenges in this field. And it should not, again, with respect, be possible to circumvent those time frames, which are very deliberately set, of course, by generating letter after letter from a public body which is simply trying to explain the basis for its original decision taken many months before in good faith. Other than that, my lords, I rely on the reasoning of, in particular, Mrs. Justice Thornton on the question of delay. And unless I can assist any further, that's my submissions.
Thank you very much.
Grateful.
Yes, Mr. Elkin.
Can I deal with the issue of delay first, since it came last? I asked the court to look at the correspondence in January to April 2021. It is not an attempt to artificially extend any period. It was an attempt to get to the bottom of the claim made by a junior officer in January, going up to the chairman of the Forestry Commission, which was in turn answered by a senior officer on his behalf. It was an attempt to get understanding as to what the Forestry Commission thought the law was on the point. There's no indication in that correspondence that it was anything other than that exercise, and it was not an artificial attempt, as one has seen in some cases, of a company trying to string things out to give itself more time. It had no reason to do that.
You say a junior official. Miss Littlejohn was the regulations manager.
Yes, but it's eventually answered. Well,
I appreciate it. It
went up.
Then sent to somebody more senior. That doesn't make Miss Littlejohn junior.
Well, she'll forgive me for mischaracterising it, but it was an attempt to explore.
I mean, the regulations manager sounds like the right person to me.
Well, the problem is titles can be misleading.
Well, I understand that, but I mean, I'm just picking you up on junior. That seems, as I say,
I'm sorry.
It was written to the regulations manager, and she replied, and on the face of it, that was the right person to write to and the right person to reply.
Well, be that as it may, it was something that wasn't foreshadowed previously, as I've said in the guidance, and we were trying to get a definitive view at a senior level, bearing in mind it wasn't in the guidance. And as I've said on several occasions, though Mr. Simons ignores this. We were not seeking to challenge or vary the felling licence. I accept there are no provisions, and I made that clear earlier for doing that. What we seek is a review of the discretion in relation to the enforcement notice. Can I say this too? It wasn't a 6-month delay. We couldn't ask for a review until the detailed planning permission was granted, which was at the end of September of 2020. There was a short delay, but it was 3 months, not 6. And we couldn't very well ask the Forestry Commission to review its position on enforcement until we had a detailed permission in our hands. So factually, Mr. Simons is incorrect on that.
The planning permission was the 28th of September?
Yes.
So the letter was the 13th of January. So
yes,
that's more than 3 months.
Well, it's just over 3 months.
Yeah.
It is what it is, but nonetheless, it was seeking to understand that the Forestry Commission, whether the Forestry Commission agreed with our analysis, and it turns out they didn't. And there's been no attempt to cover up what we thought the position was. You've seen the correspondence. The notes of the meeting may not have been taken by the Forestry Commission, but it's not suggesting it was there's anything misleading in that, at least to the extent that we indicated to the Commission at that meeting that we were twin tracking with the planning application. The position is this, though, that you've got a subsisting situation where the forest, as I submitted it in opening, it isn't a simple decision. It's a question of a subsisting condition of unlawfulness if we're right on the construction of the statutory provisions. The Forestry Commission is saying, no, we are holding you to the enforcement notice, and that will continue to apply until it effectively runs its course when the 10-year stocking period, 10-year retention and maintenance period expires. So it's not simply a one-off decision, it's a continuing set of circumstances. And as I've said, Mr. Justice Carr in the Fire Brigade's case suggested that that might be something that required more care than simply dealing with a single decision. Equally, it's unattractive for a public authority if it has got the law wrong, which we say is the case. Of course, it's a matter for the court whether that's right. But if it has got the law wrong, that it should be allowed to continue to maintain that position, because it will continue to maintain that against the applicant in this particular case, as well as anybody else, for the indefinite future. So my respectful submission, the submissions on delay, the learned judge was wrong because we weren't targeting the enforcement notice. The enforcement notice we couldn't target at the time. We didn't have a valid ground of appeal, and we couldn't say even that you ought to be reviewing your position because we didn't have detailed planning permission either.
Well, the true analysis would be this, wouldn't it, following from your submissions? You said no valid ground of appeal.
Yes.
And it would follow from that that Section 25 did not afford you an appropriate alternative remedy. This is not a case where it can be said that judicial review didn't lie because you had a statutory remedy available to you, because you say those two grounds in 25.1 simply weren't available here. No. So the question is whether any justiciable act by way of a claim for judicial review was promptly challenged by a claim. And you say it was, because promptness in a case such as this is a rolling concept.
Yes.
In other words, actually promptness doesn't arise on that basis, because every second, if you like, or every day, the situation is renewed.
It's not a case where difficulties are caused to the Forestry Commission as a result of challenging the definitive letter, as I've called it, of the 1st of April rather than the email response on the 15th of January. There's no issue arises. The individual at risk is the applicant itself. It was trying to get to the bottom of the legal contentions. It received a number of responses, all of which aligned. I entirely accept that. But it was trying to test that position before it launched legal proceedings, which in my submission was a responsible act. The pre-action protocol letters before claim procedure then followed that letter of the 1st of April.
In the Fire Brigade's case,
Yes.
Can you just remind us what was the act challenged?
Just allow me a moment. It's
Tab 12.
13. No, it's in tab 12.
Oh, yeah.
It was the question of compensatory rest under a directive derogation.
Yeah.
And the passage that I rely on is at paragraph 142 on page 270, where Mr. Justice Carr said that whether in the present case the illegality is continuing, there's a concerted plan to continue the unlawful conduct. The consequence of granting relief must still be considered, but the case for relief is stronger where there's no plan to put an end to the unlawful conduct and every intention to continue with it. well, it's not precisely the same circumstances, clearly, as those, but it is a case where Forestry Commission has made it perfectly plain, we say wrongly, to maintain that it can't, not that it won't, but that it can't review the enforcement notice, and it is not intending to correct that situation.
I mean, this was quite a strong case. I noticed that he goes on to say it's an affront to the rule of law.
Well, my Lord,
I don't think even your eloquence, Mr. Elvin, you don't say that in the present case. I quite understand that you say this is an unacceptable muddle,
yes.
but I think you might be going it a bit to say it's an affront to the rule of law.
Of course, I don't put it that highly. I just draw out the thread that it's an assertion of a position we say is wrong in law, and it's a refusal to correct that. Lords, I don't think there's anything else I can say on the issue today. I've set out my position. Yeah. Can I correct a couple of factual mistakes by my learned friend? The first one related to the new document that we were given. What he didn't refer you to were pages 4 and 5 of the officer's report, which makes it clear that the officer was having regard back to the 2016 permission and the conditions for felling and improvement there. If you look at page 4, condition 9, the corridor, you're reminded this width relates to details submitted under the current application, the necessity of the habitats regulations, compliance with the outline planning permission, and that reference number is the 2016 permission I showed you this morning. And any conditions imposed on this or subsequent planning applications would need to be adhered to. So officers were not ignoring the position of trees. They considered it had already been dealt with by the 2016 outline and were drawing attention to it here. And then they note on the next page, under relevant site history, that this permission remains extant at the top of the page. So it's not that they didn't consider this because the trees had been felled. They looked at it in the context of the outline planning permission with those details that I drew your attention to this morning. The second factual mistake Mr. Simons made was the one I corrected before the end of my submissions, which is that restocking was complied with. Having been served with the enforcement notice, Arnold White did not consider that it could ignore the position, and it has restocked. Mr. Williams' witness statement refers to that, as I mentioned earlier.
So there was the reference in the letter to the intent not being to restock, but you say that subsequently they have them.
Well, they were faced with the potential for criminal liability if they didn't, given the service of the notice. My Lords, can I come back to the general position? A lot of what my learned friend said about different regulatory regimes, yes, of course there are a lot of regulatory regimes, is answered this way. It is as clear as it could be that Parliament considered that the Forestry Commission's role with tree felling did not apply where the planning regime had granted a planning permission within section 9.4d. If my learned friend was right, that provision would not be there. Parliament clearly considered the role of the Forestry Commission in respect of tree felling regulation was subsumed within the planning regime. And all that he submitted about one regime not superseding another, etc., is answered by that provision and by section 15. What my learned friend and the Forestry Commission's position leaves us with is perhaps not an affront to justice, but an affront to common sense. And my learned friend's submissions turn on the fact that if you don't do planning with reserved matters first, you may end up in an entirely different situation, despite the fact that the circumstances of the trees and the site may be identical. If you do it ahead of time or indeed you haven't got planning permission at all. Let me give you an example. What if you have someone who has a site, wants to clear the trees, gets a felling license with restocking, etc. conditions, and then a year or two later, despite the 10-year condition point, either the local authority looks to allocate the site in the local plan for housing, or a new landowner comes along and wants to develop the site and gets planning permission. In neither of those cases is it possible for that to happen on the Forestry Commission's case. Section 24, the service of notices, applies not only to the holder of the licence, but to the owner of the land. So it isn't simply an in personam situation, and indeed the Forestry Commission have made it clear that they consider it binds successors in title. Let me give you the reference, if you give me a moment.
That would
Page 2.
That would be right, wouldn't it?
Supplementary bundle, page 203.
That's what you'd expect it to
Well,
bind successors in title, because otherwise somebody could sell it and then
Yes, you sell
somehow avoid.
Sell it to your brother and get your brother to.
Exactly.
No, absolutely. It would be too easy to employ anti-avoidance. It's an anti-avoidance measure. But it does lead to absurd results such as that. If therefore a felling licence is granted subject to these or similar conditions, it means the land is effectively on the Forestry Commission's case, because they say there is no power to review. It is sterilised for the period of the felling licence. And it's clear in my respectful submission that that is not what was intended, because Section 9.4d, albeit that it's imposed in the specific context of do you need a felling licence, Parliament thought the planning permission should be sufficient, if it immediately required felling, to take it out of the regime. And yet you get those absurd results simply by differences in timing. What's been described by my Lord the Senior President and my learned friend as a quirk, there is nothing unusual about developing land and then selling it off in parcels.
I don't think a quirk came from me.
It might have been Lord Justice Coulson in that case.
I'm not disowning it. I'm simply ensuring that it's not misattributed.
Shall we call it the factual context?
To be clear.
Well, I'll simply take it that my learned friend adopted it, whoever said it. But whether it's a quirk or not, Mr. Williams's witness statement explains to you the circumstances, and I'll just give you the paragraph references. It's paragraphs 22 through to 27, pages 10 to 11. And the difficulty, the learned friend says, oh, well, why didn't you go and get reserved matter straight away? Well, the short answer is, if you are developing a site with infrastructure to then sell on, of course, there is, it's for the individual site owners who buy the sections of the site which have been serviced to put in their own reserved matters applications. They will know what development they want. And it's a perfectly rational explanation, and it's not unusual in the planning world for such matters to occur. House building sites, large house building sites, sorry, I'm being anecdotal now, but they are frequently parcelled up amongst individual land, housing developers rather than developing a whole site themselves, and they'll each do their own section. So the idea of a phased development of a large site is far from unusual. But on the quirk of timing, the Forestry Commission's position is not only are you caught by the felling licence, but you're caught by the enforcement notice, and thereafter, to use his words, we're stuck. That cannot be a rational construction of a statutory scheme. It does not require significant violence to be adopted with regard to the statutory words to imply a power of withdrawal. And I'll come to the provisions the learned friend relies on in a moment. I've already made the point. It's clear that there's a discretion whether to serve an enforcement notice in the first place. That of itself suggests there should be a discretion to review it. There is nothing, subject to my learned friend's points about specific provisions within the Act, there is nothing in the scheme of the Act which would be repugnant to the idea of an implied provision. The Forestry Act lacks the sophistication of the Town and Country Planning Act, but it didn't have the benefit of Lord Carnwath reviewing the enforcement provisions as the Town and Country Planning Act did. The provisions my learned friend relies on don't support the proposition he makes, because what are there referred to as withdrawals are in fact are the directions given at the conclusion of an appeal to an independent party. They're not the power of the Forestry Commission to withdraw. They are the consequences of a successful appeal. Section 17B, which was his first example, is the Minister may, after considering the committee's report, direct the Forestry Authority to withdraw the notice or notify the objectors, etc. It's like a magistrate's court quashing a notice, or it's like the court on a planning enforcement notice case quashing the notice and remitting it to the Secretary of State or to the inspector. It's not a withdrawal at all. It's not telling you what the Forestry Commission can do. It's the power of the Minister to direct a consequence on allowing an appeal. Similarly, under Section 20, subsection 2, precisely the same point, it is directing a consequence of a report on the reference in relation to felling directions. Again, it is not addressing any discretion on the part of the Forestry Commission. And Section 25(4) is nothing to the point because it's simply another series of powers consequential on the allowing of appeal against an enforcement notice. So would the court like the page numbers?
Well, no, it's 33, isn't it? 33 and 34.
33 and 34, section 25. 17B is 25, and 22 is 28. But they're all dealing with the powers of the Minister consequential upon a successful appeal. So it's
they involve a third party rather than the Forestry Commission themselves.
Yeah, it's a direction as to consequences following adjudication. So it tells you nothing about the powers of the Forestry Commission. What it does show is that those provisions are not inconsistent with an implied power which goes along with the express power, the express discretion to serve an enforcement notice. And at the end of the day, other than those provisions, Meloditrone can't identify anything other than by saying, oh, well, the Act is self-contained and perfect of itself. There is no good reason for excluding an implied power and every good reason to ensure the maintenance of the general purpose of Parliament, which recognised the role of the planning system in this context, which I've already said enough about in opening. But if there is that implied power, it also allows them to address what my Lord said earlier about, well, what happens if they realise they've done something wrong or that there's a change of circumstance. For example, if there's a restocking condition and then there's and what's being restocked is subject to significant disease, like ash dieback or whatever, and the Forestry Commission realise they can't maintain the position set out in the enforcement notice and the conditions.
Can I just ask, Mr. Robin,
yeah.
What do you say is the scope of the implied power for which you contend?
Well, there is. If you go back to the power to serve the notice, it is simply may give a notice. So there is a broad discretion on the Forestry Commission, presumably taking into account all the relevant circumstances, as to whether or not to serve a notice. Yeah. Under the planning legislation, it has to be expedient. But under the Forest Regulator, it's just a broad discretion in the context of the Act.
Yes.
And the context of the Act includes Section 9.
So you can challenge, potentially by way of judicial review, the decision either to serve it or indeed not to serve it.
Yes.
Right. But you're contending for something different, as I understand.
I'm not talking about a challenge to the notice. Or to,
I understand that as well.
It is simply that there are circumstances which will arise from time to time, and this case is one of them, where in order to give better effect to the statutory regime, it makes good sense to imply, and indeed consistent with the statutory regime, a power to review the notice, and either to modify it or withdraw it.
This is what I'm trying to get at. What exactly is the scope of this power?
Well,
if there's a power and it's not exercised, then in principle you might say, well, somebody ought to be able to judicially review the failure to exercise the power. So if one was in that situation, what are the parameters?
Well, the parameters are like any broad statutory power, and that they have to be construed within the context of the statutory provisions within which they're found. That is to say, the function of the Forestry Commission and the purposes of licensing.
But the statutory provisions say you can appeal on certain limited grounds, and that's that.
Yes, but that doesn't mean to say that circumstances can't change, which makes it desirable in the public
so
interest.
is it change of circumstances? No, I'm sorry to sort of nag away at this,
No.
Mr. Ovey. I just want to understand if we're saying the Forestry Commission had a power to ... and it wrongly decided ... What are the missing words?
Well, the way I would put it is the power to review or modify has to be exercised having regard to the purposes of the provisions, which, that is to say, they couldn't be done for extraneous purposes. And the classic example is the planning case of Westminster City Council of using its powers to create a subway in order to create conveniences under the road. Or power to create conveniences under the road and putting in a subway as its real motive. You've got to do it for the purposes for which the statutory authority is acting. And one of the purposes, one of the statutory part of the statutory context, is in order to give effect to Parliament's intention that where planning permission immediately requires felling, then that is given effect to, and that you don't create a circumstance where you've got either land which is sterilised for a significant period of time, even though it may not have been the act of the current owner, and the matter can be said to be covered properly by a grant of planning permission, which falls within the intention of Parliament to exempt that from the licensing regime. So it's got to be within the scope of the statutory regime. It couldn't be done for external reasons, and it couldn't be done for improper purposes. But as I come back to the first point, that there isn't any guidance as to the exercise of the discretion to give the notice. I mean, clearly there has to be a breach in order for a notice to be served, but there's a discretion on top of that. But that's not directed either, so it must be within the statutory purposes. The Forestry Commission must have regard to the circumstances which exist in order to decide whether or not to proceed.
I'm just looking at the relief or the remedy sought in the claim, which is on page, the core bundle C109.
Sorry, I've got the wrong bundle open.
Yeah, tab 12. There's a range of relief sought. Sorry, 109. Thank you. Including declaratory relief, but at 5, well, 4 is a declaration to the effect that the defendant does have the power to withdraw. So that's a declaration as to what the law is.
Yes.
And then 5 is a mandatory order, I think, an order to the effect that the conditions of the felling licence and the notice should be withdrawn. That's I think, translated into tangible relief would be a mandatory order, would it?
Yes.
Compelling the
Well, I think more accurately it would be the withdrawal in part, because it would be in the context of the detailed permission, which doesn't cover the entire site.
But it goes further than compelling them to consider withdrawal.
Yes, it does. Well, it's the point that my Lord Justice Coulson raised at the beginning. It's if the court is with me that there is an implied power, and that the purpose of the implied power includes giving effect to the general intention of Parliament that the planning regime should take precedence where there is a planning permission which immediately requires, etc., i.e. Detailed planning permission, then if the purpose is to ensure that those schemes that have got a detailed planning permission are not subject to the regime, in my submission, that's, as I put in response earlier, my submission is that gives rise to a situation where the Forestry Commission couldn't rationally do otherwise than to give effect to that principle. That is to say, not overlapping with a planning permission which did immediately require felling.
So you're really asking the court to compel the withdrawal of the
Yes.
enforcement notice, are you?
Well, at the very least, it ought to consider
Well,
in
it's
the light.
actually, it says, to be fair, it says the conditions of the felling licence and the notice should be withdrawn.
I've accepted that the felling licence. I can't challenge.
So it's the notice. You're actually asking the court to compel, to mandate the withdrawal of the enforcement notice.
Or its partial withdrawal in accordance with the detailed planning permission.
Yep.
And help me with this. We know that the restocking conditions hadn't been addressed, hadn't been dealt with, as at the 30th of June.
They have been.
They have been now.
Yes.
No, but I'm looking at the power. This would be a power that you would say would apply regardless of the fact that the restocking conditions that were part of their licence had not been complied with.
Yes.
So would that be for all time? This power would apply even if the restocking conditions had not been complied with, and there was no planning permission for a year or 2 years or 3 years?
Well,
What's the temporal limit of the power?
The power is there. Not, and the learned friend is wrong in my submission to say this is retrospective. It's not retrospective. It's a review to judge the circumstances at the time of the review. It's at the circumstances as they subsist at the time of the review. But the logic of the matter, my lord, would be if planning permission were granted, say, 4 years after the felling licence came into effect, then the answer would be yes, they should review it. Because...
And 4 years after the restocking conditions should have been complied with, but not?
Well, if the restocking condition hasn't been complied with and no planning permission exists, then there would be a valid enforcement notice and a prosecution if it wasn't.
Yes, no, but I'm not looking at the power.
Yeah.
This is the power that you say must exist. And I'm just trying to identify what the temporal constraints of that are. Because we know that in this case, you say there's a power, notwithstanding the fact that the restocking conditions had not been complied with. You say, well, it was only, whatever it is, 3 months later that planning permission was given. So I'm just exploring, would it make any difference if it was 3 years later?
Well, my lord, I think the way I'd put it is this, which suggests it may be longer than that, but it would be so long as the enforcement notice subsists, which is in the case of if you have a stocking requirement for maintenance for 10 years, it would be the 10-year period, because if a planning permission was then granted, which met all the requirements, then there's no reason in my submission why the Forestry Commission shouldn't review it at that point. Because otherwise you can get all sorts of oddities with temporal, the temporal, or the order in time in which these things are done. And if Parliament has taken the view that planning permission is sufficient for these purposes, well, the difficulty is you could have a felling licence in year 1, land is sold in year 3, and someone comes along with development proposals in year 4. Permission is granted, but the Forestry Commission turns around and says, we're stuck. You've got another 6 years before you can do anything because of the felling licence conditions.
So it's at any time before or after the restocking conditions came into effect?
Well, yes, during the subsistence of the stocking conditions.
And but what then, does it follow from that, Mr. Elvin, that you say it would be a defence to a criminal charge? To say, well, we're hopeful that we might get planning permission at some stage.
Well, it might amount to a reasonable excuse in that event.
That's really the point I'm asking.
No, but the problem with that is...
It seems to me, and I'm sorry to talk across Mr. Elvin, I'm just really keen to grasp the parameters. It would seem to me that anyone in this sort of situation could get the felling licence, clear the site in the twinkling of an eye, and then for the next decade say, well, true enough, I haven't complied with the conditions and I don't propose to do so, but don't prosecute me because I'm hopeful I'll get planning permission.
Sorry, my Lord, I think.
Excuse me, Mark.
Yeah, my Lord. I think the point is it really only arises if an enforcement notice is served.
Yes. Well, let's suppose it has.
And the difficulty is that it provides a potential defence to a prosecution. And my Lord, the answer to your question, level 5 is unlimited fines
Yes.
under the latest
Yeah.
provisions. The difficulty is you're exposed to the risk of prosecution, whether or not you may or not satisfy the magistrates that you have reasonable excuse on the day. One shouldn't be exposed to such a situation and to the risk of prosecution if you fall within the broad parameters in which Parliament has said, well, if you've got planning permission, you shouldn't be subject to the felling regime in the first place. That's the difficulty with this. The Forestry Commissions, we have no power to do anything once we've served an enforcement notice approach, means in such a circumstance, it's entirely down to an accident of timing, even in a case which isn't the same as ours, where you just have the felling licence granted maybe a short period of time before the land's sold. But in my submission, the prospect of a potential defence isn't sufficient to remove the risk of jeopardy that the criminal sanction creates. Can I correct in this context the point that Malone and Friend was making, that, well, we'd put the 10 years into the application. The reason for that is it's a standard requirement of the Forestry Commission. If you look in Supplementary Bundle 2, the felling permissions guidance that I showed the court earlier, tab 29 of Volume 2, page 283, you'll see that the requirement for restocking and maintenance for 10 years is the standard requirement of the Forestry Commission. It was put in because that is what the Forestry Commission expects. And it's not restocking as such which is the vice, it's the maintenance requirement. They can be restocked, and indeed, as I've said, they have been restocked. It's the fact that you have to maintain them for 10 years, which prevents any further implementation of a future planning permission for that 10-year period. And the Forestry Commission's "we're stuck" approach effectively means that the felling regime provides an absolute bar to the development of land, because you can't put in a subsequent application, because you can't vary the existing felling licence. The enforcement notice can't be varied because Malone and Friend says, the Forestry Commission says that there's no power to do so. So you really are in a bind, and the Forestry Commission can therefore sterilise the development of land for a 10-year period by imposing its standard maintenance conditions. That is the real difficulty that its position creates. Regardless of what the local planning authority says, whatever it thinks is in the best interest of the area, is irrelevant to those circumstances. And far from being a simple and clear regime, it is one which causes serious difficulties. The fact there hasn't been litigation to date doesn't demonstrate much in my respectful submission, because it may simply not have been appreciated.
Sorry, I'm not sure I really understand that.
Well,
the Forestry Commission seem to have been pretty clear in their statements in this case.
But not in any published guidance.
No, so be it. But I think Mr. Simon's point was that the reason it hasn't caused any problems is that almost invariably people do things in a different sequence, and then the problem is avoided.
Well, we don't know that, my Lord. And we don't know what the circumstances of other cases. It's a dangerous supposition Mr. Simons invites the court to make, based on no evidence whatsoever from the Forestry Commission. And what I say is that the sequence of developing land in phases, such as was proposed here, is not unusual. And there are plenty of cases in the reports about phased planning permissions and the like. And indeed, the master plan here, I think, shows phased development was anticipated. So, my Lord, I don't think I can add significantly to the points I've already made. Can I just check my notes to see if there are any responses to Mr. Simons?
Of course.
My lords, unless there's anything else I can assist the court with, those are my submissions.
Oh, thank you. Very clear indeed, Mr. Owen. Thank you. It will not surprise anybody to hear us say that we shall reserve our judgments. In due course, as soon as may be, we shall provide drafts of our judgments for typographical and minor factual corrections only. They will be circulated to the parties in advance of hand down. At that stage, please, an agreed order should be prepared. If any matters in that order cannot be agreed for whatever reason, submissions should be submitted to us at the same time as the corrections to the draft judgments, please. In other words, the normal arrangements apply. Thank you all very much for the clarity and care of your written and oral submissions.